Welcome back. You're watching NewsX. My name is Vineet. Well, the woman accused of orchestrating her own husband's murder on their honeymoon is out on bail. Tonight, we ask why Sonam Raghuvanshi was arrested last June, accused of conspiring with her lover and 3 hired men to kill Raja Raghuvanshi. A 790-page charge sheet named all 5, but in April, a trial court freed her, not on merit, but on a technicality or typo. The court found failed to properly, the police, they say, communicate to her the grounds of her arrest as required under the Constitution. The arrest memo even wrongly called her a deserter from the armed forces. The Meghalaya High Court upheld that bail on June 29, calling the arrest paperwork ridiculous. Today, both the state and Raja's family took it to the Supreme Court. The bench refused to cancel her bail, saying, and I quote, "Bail is the rule, jail is the exception," but it also admitted on record, "We do have reservations." We'll talk about this with our guest. Joining us on the platform at this point in time is Mr. Sanjay Sahai, former ADGP Karnataka. Tahira Hassan, women activist, is also joining us on the program. Advocate Chandni Preeti Shah, political analyst, with us on the broadcast as well. Thank you everyone for being a part of this conversation. Mr. Sahai, let's begin with you. Let's get a police angle into this. It's a technicality, nevertheless, but the gravity of this crime is also extremely high. In fact, when this entire murder was discovered, it was as big a sensation as the Sia matter is today. What do you make of the bail that has been granted, and of course the parents and the supporters of Mr. Raghuvanshi extremely upset about this bail?
It is not a question of parents and supporters and parents and people who are anti the judicial process. That is not the issue. I think everybody in question, the investigating officers, the Meghalaya police, the Meghalaya government, and today Solicitor General is also representing this case. Where were all these people when the charge sheet was being verified and validated and then being sent to the court? So that is where the whole problem starts. And when we are talking about the typo, I went into the details of at least 2 articles regarding this. And typo means that instead of 1031, some place or in one particular document, it is written 403. Now 403 is not existent in Indian law as it stands today. The crux of the matter is that whatever might be the investigation in this case, the documentation has been extremely shabby. And when you get into the documentation part of it, and I have put in around 31, 32 years in the Indian police service, it will be very strange, it is ridiculous to find any case where document after document, you are having a wrong section of law which is non-existent. There are large number of documents, checklist and arrest memo and variety of other things, where either the checklist is not filled up or there is a defective section. We are completely with the investigation of the case, but Meghalaya police also knows that when it comes to judicial trial, these are the couple of issues which will be raised. This is not a nature of a technicality wherein only at some point in time, by mistake, this has happened. Charge sheet has also been accepted, the trial continues, and all the other judicial requirements of the judicial trial requirement goes on. Now, when we are talking about that the bail did not get cancelled, now the issue is today has been just an interim order. And the Supreme Court of India has very clearly said that they have issues with the reasoning of the Meghalaya High Court. If you need, we can elaborate upon it, but it suffices to say that they have an issue with the reasoning of the High Court and the process by which they went and they upheld the bail. Now, the only thing which has happened is because of a caveat, now the case is posted for July 9th when the counter affidavit will be filed. Based on that, the final judgment on whether this bail will be upheld or not will be delivered. So that is where the case stands now.
Chandni, as a lawyer, what do you think could have been done differently, to make sure that the culprits at least stay behind bars for the duration of this trial? Obviously, this was a cold-blooded murder.
Vineet, this was a cold-blooded murder, and everything was pointing towards the accused. But again, If it had been a one-off typo in a single document, then it would not have been such a big thing, and the bail would not have been cancelled. But what has happened is that this non-existent section has been repeatedly put across the arrest memo, the checklist that justifies this arrest, the inspection memo, even the case diary has this wrong section. So under the article 22 1 of the Indian constitution, it is said, it is that it guarantees that no person can be detained without being informed of the specific grounds for the arrest. So Sonam was informed that she is being arrested on 4031, whereas she was actually being arrested on 103. So this is a very technical ground, but still it makes a big, huge ground for her cancellation of bail. Now coming to what could have been done is that this was a systematic failure, and it could have been avoided. It was not like the prosecution and all did not have those documents. They could have corrected it, and they did not raise this. This is the reservation that the Supreme Court has also shown, that this was not raised while the bail was being rejected until now. Why is this being brought up right now only? So this is exactly what the Supreme Court has also said. But again, um, they have not endorsed the High Court's reasoning, but they have just chosen that right now they do not want to disrupt the status quo, whatever it is. But they have maintained that they have a displeasure towards however the judgment has been passed.
Tahira ji, is this also injustice? The way the police has not been able to, put down on paper also as to what category of crime this is supposed to be.
Yes, it was a hideous crime, brutal murder. But I always say, when the police does not, investigating agencies don't collect scientifically the evidences, then these type of lapses happen, because whatever the evidences are collected and produced in the court, the honorable court gives the judgment on those evidences only. But I think this time what we must raise the question and our voice is this, that the granting bail doesn't mean that Sonam is innocent. It is a conditional bail, and even the murderer also get the bail. Even he has a right to get bail until or unless he is proved guilty. So this time, it doesn't mean that this bail is going to make her innocent. But thing is this, the trial must be speedy. There should be no unnecessary delay in the trial. It should be fast-tracked. And that's otherwise the witness will get hostile, and the whatever evidences will be collected, they will also weaken. And the redressal of such cases where the heinous crimes are involved, they must be through the fast-track court within the limited time. So again, I will say, so the witness will not get hostile, and they will not be, these people will not be, the accused will not be able to influence the evidences and all. And justice will not be delayed, and the people will not lose their hope in justice. And their faith will be not weakened in this case. So I think that is more important, that we must raise the voice that the trial must be within the limited time. There should be no unnecessary delay. And the evidences must be collected properly, scientifically, and that should be produced in the court. And the police has made this, lapses have been made by the police, as the lawyer and the IPS officer said, then I think the accountability must be fixed on them also. Why the evidences have not been collected? We have seen in the Chabra case also, that was a heinous rape case, but the all accused was acquitted because the evidences were not collected properly and produced in the court. Within limited time, trial was not done. So I think that is more important this time if we want the justice. Then we should raise this voice, our concern on that. That trial should not be delayed. It should be fast tracked, and the redressal of this case should be fast through the fast track court. And the other thing is this, that if the conviction rate is remains so low in whatever case, the women case or the criminal cases, then these laws which we have, very strong laws, whether BNS or whatever, the lawyer was talking, the 103 or whatever the section, but these will be not deterrent unless or until the laws are implemented properly and the guilty is convicted, then there will be fear in people. They'll say, oh no, we can engage a best lawyer and can, I mean, just get away after committing heinous crime. Nobody can stop us. Next time they will commit more heinous crime. So these are the important things on which we must pay some this attention, and we must raise these questions, which are more important questions, I think.
Mrs. Sahai, how do you respond to that? In fact, the lawyer representing Mrs. Raghuvanshi also went on to say that she was not informed about the grounds of her arrest. The court went on to say that that technicality cannot suffice for granting bail because the arrest can happen again as well. Do we also need to focus on the sensitivity sometimes of these cases, or perhaps every case, and how the police deals with it?
I'll get into a couple of things. This whole bogey which has been created against sentiments versus judicial trial legality, lack of legality, concern, and that people are numb in judiciary. I think I don't go by that. I think every single element of the criminal justice system, from the registration till the court, has to be equally sensitive. But that does not mean that if there are lapses of a monumental degree, that can be wished away. And that is why the police, the prosecution, they have been trained in that manner. And they are supposed to perform in these situations. Now, the accused has not been intimated of the grounds of their arrest. Now, that has already been, in a way, told by the Supreme Court that this issue was not there. And this is created as a alibi at a much later stage. The main issue in question here is that instead of 1031, they have used 4031, which is not, and it is across board. I literally have no faith on this investigating officer, whosoever this fellow might be, and there might be constables and class below him who have just collated literally anything and everything and then added it up to a case. From there, you go to the prosecution stage. Every single charge sheet, it is validated by the prosecutors who works with the police. There are prosecutors who work inside the police department. There are prosecutors who fight our cases in the courts of law. Now, who are the people who validated that? And inside the police department is also from the inspector or whosoever is investigating, at least till the level of SP, every single case, the permission comes from there. Otherwise, these cases cannot be charge sheeted. These are the cases of a totally different level. And when there is national limelight, then you are bringing up a case where the section is faulty. Here the judge is not at fault. It is not the sensitivity of the judge. It is the sensitivity of the local police. It is the sensitivity of the prosecutor. It is sensitivity of the people who have actually directed, instructed, supervised the investigation of this case. Now, it is not one versus the other. It is, everything has to add up as a sum total which is successful. That is my point of view, because every time we are putting this versus the other, that versus this, it is this, and that will deliver the results. And over again, the same thing is happening. Even in this Sia case, now they went for the scene recreation. They have thrown the dummy there also. The dummy is still there. They have been very done in a very commendable manner. All that which transpired to this came coming to light. Now the recreation part, because it does not have admissibility in the court of law, to best of my understanding, so they have not bothered to go ahead with that and find as to what happened when this dummy came down. So what I'm saying is lackadaisical, casual approach, sarkari sort of approach. I don't think this works in criminal investigation of heinous cases. We are finding issues in large number of cases of this nature. This is where we stand. The police and the prosecutors certainly are in the dock because it is case over and over again. And my fellow panelist, who is a lawyer, also elaborated the same thing. So how do we hold anybody responsible, and how do we say that the police, there's the judicial process, because we can't tell this judge or that judge. The judicial process is insensitive to the demands of the day, and somehow or the other is a bystander to this sort of heinous crimes which is happening in the way it is happening. I don't subscribe to them.
Chandni, well, you know, there also is a typo here, right? And the question is, can a typo actually dictate this kind of a bail in this kind of a high-profile case?
Again,
Isn't that something that can be fixed and resubmitted?
yeah, that's what. That it was not one simple typo. Okay, it was not one misspelled word. What happened was that across 5 different documents that has to be very watertight, you know, to hold an accused inside the jail, so that her bail or his bail does not get cancelled. Okay, now all those documents have a section which does not exist only in the BNS, in the new law. Okay, so the 403 section that I said, it does not exist. And even if it is debated that it by mistake they wrote for the IPC section, then also under IPC 403 is very, like, it's insignificant. It's for misappropriation. So that also does not hold. So the technicality on which the entire thing was based was only this, that the section does not exist. How can she be arrested without the section? This was the core base of the entire bail argument that the defense did, and rightfully so, because the prosecution could have avoided this. So,
Is this more of a punishment for the prosecution and the police, and not so much, much as, you know, looking at the fact that assumed innocent until proven guilty?
yes, because see, again, bail is not acquittal, right? And Supreme Court has not even said that the High Court is right. In fact, they've openly shown their doubt about the judgment. But what have they recognized is that the egg cannot be unbroken. It is like she's already out. She's complying with the conditions, and the trial now would be the right place to decide her guilt, right? Because see, the law is very clear that the gravity of an offense cannot overshadow the sanctity of due process, and over here the due process has not been followed. So that is why, if the police is failing to tell an accused that why are they being arrested, then the courts will have to protect the constitutional rights over the police's incompetence. And this is exactly what has happened. But again, the bail can be cancelled if anything, if she violates her conditions. In fact, right now the focus should only be, as ma'am said, their trial should be expedited. That should be the sole focus of the prosecution. The correction of the records, like now they have to be very strict and flawless with all the trial documents that would go. Like they have to see that section 103 is reflected and there is no further technical loophole that can be exploited by the defense. And I think they should also ask for monitoring compliance. Means,
All right.
Sonam should be
Chandni,
heavily
we've run out of time, but I appreciate the time you, Tairaji, and Mr. Sahai gave us. Thank you so much.